Good
La grabación ha
morning.
comenzado.
Good morning, and thank you for joining us for our second Know Your Rights session over small business. This presentation will be by Austin Equity and Inclusion and Texas Immigration Law Council. Before we begin, we have an important notice. The information shared during this webinar is provided for educational purposes only and should not be considered legal advice. This presentation reflects federal, state, and local laws, policies, and guidance in effect as of the webinar date. Immigration laws and policies can change frequently. Any changes that occur after the webinar date are not reflected in this presentation. This session is intended to provide general information and may not address every situation or individual circumstance. If you have any questions about your specific situation, we encourage you to consult a qualified immigration attorney or other trusted legal service provider. If I can get some help in Spanish.
Aviso importante. La información compartida durante este seminario virtual se proporciona solo para efectos educativos y no debe considerarse aviso legal. Esta presentación refleja leyes federales, estatales, locales, políticas y guías que están en efecto hasta la fecha de este seminario virtual. Las leyes de inmigración y las políticas pueden cambiar frecuentemente. Cualquier cambio que ocurra después de la fecha de este seminario virtual no está reflejado en esta presentación. Esta sesión tiene el propósito de brindar información general y podría no abordar cada situación o circunstancia individual. Si usted tiene preguntas acerca de su situación específica, nosotros le aconsejamos que consulte con un abogado calificado de inmigración o con su proveedor de servicios legales de confianza.
Thank you. Additionally, we will have interpretation available for this presentation. If you are on your computer, you will find a globe icon at the bottom of your screen. If you click on more, you'll see language interpretation. If you are on your tablet or phone, click the three dots, more language interpretation, and select your preferred language. Don't forget to press done. Please, if you have any problems with the language, don't suffer in silence. Let us know in chat. Also, please take a moment to rename yourself in the meeting so we know who you are.
En esta reunión hay interpretación. Si están en sus computadoras, presionen el icono del mundo en la parte de abajo de su pantalla o el icono de más y encontrarán interpretación de idiomas. Si están en sus teléfonos o tabletas, hagan clic en los tres puntitos más o more, seleccionen interpretación de idiomas y su idioma preferido. No olviden presionar listo o finalizar. Por favor, si tienen algún problema con el idioma, no duden en comunicárnoslo a través del chat. Además, por favor, tómense un momento para cambiar su nombre en la reunión para que sepamos quiénes son.
At this time we will be beginning the interpretation. Thank you.
Thank you, Gabriela. Good morning, everyone, and welcome. Thank you for joining today's Know Your Rights webinar on how immigration enforcement policies affect small businesses owners, entrepreneurs, and also workers. My name is Uma Garba, and I'm the Immigrant Affairs Manager with the City of Austin's Office of Equity and Inclusion. Austin Equity and Inclusion works to make Austin's a welcoming and inclusive community for everyone. Through our Immigrant Affairs program, we help connect immigrant communities with trusted ID information, city services, and also community resources. Throughout the year, we offer Know Your Rights webinars like this one, citizenship information sessions, and clinics. We share educational resources in multiple languages, and we partner with organizations across the community to help people stay informed and know where to find reliable information. We're especially grateful to partner with the Texas Immigration Law Council for today's presentation. The team has been an incredible partner in providing accurate, up-to-date legal information to the community, and we are thankful for their continued collaboration. I also want to thank our Spanish interpreters who help us provide this information simultaneously in Spanish. We hope you leave today's session with a better understanding of your rights, practical information you can use, and also some knowledge where you can turn to find additional support. At the end of the presentation, we'll have time
Votación.
for Q&A questions. If you have a question during the webinar, please type it into the Q&A session or in the chat, and we will do our best to
Y
answer as
ah,
many as possible. We also ask that everyone remain respectful in the chat to maintain a welcoming environment to all participants. Now, I would like to introduce today's presenter. Bobby Painter is with the Texas Immigration Law Council, a
el Consejo de
nonprofit
Texas Immigration Law, una
organization
organización
dedicated to advancing and protecting the rights of immigrants and refugees through legal services, advocacy, and community education. Bobby spent over 10 years at the Austin-based immigration nonprofit American Gateways, where he served in various roles, including staff attorney, director of pro bono services, interim executive director, and legal director. Throughout his career, Bobby has represented hundreds of clients in a range of immigration matters, including asylum, removal defense, and humanitarian visa applications. Bobby is a graduate of Macalester College and the University of Minnesota Law School. Bobby, thank you for being with us today. I will turn it over to you.
And Bobby, before you start, can we make sure both interpreters are assigned to the Spanish channel? Okay, I see a thumbs up from Lena. Okay, great. Thank you so much. All right, Bobby, all you. Okay, we cannot hear you.
One minute.
I heard that.
Can you hear me now?
Yes.
Sorry, I have a very fancy podcast mic, and I just muted myself and didn't know how to unmute myself. So we're good now. And can you all see the construction workers on the first screen?
Yes.
All right, fantastic. All right. Well, thank you again, Uma, for that introduction. And thanks to the interpreters and everybody at the Office of Equity Inclusion for hosting us again today. I'm going to do my best to check myself and speak slowly because I know I have flabbergasted the interpreters in the past by running through this a little too quickly. So don't hesitate to call me out if I go too quickly. My goal, though, is to leave enough time at the end where I can answer everyone's questions. So I will try to go through the slides at a steady pace. As Uma mentioned, the focus of today's presentation will be on what employers and business owners can do to not only protect their business, but to protect the rights of their employees. I'm going to start today by talking about why this matters. I'm assuming many of you already have a pretty good understanding of why knowing your legal rights and responsibilities is important for protecting your workforce, but it's good to set the stage with that. I will then talk briefly about immigration enforcement in Texas specifically and how it might come up in the context of a commercial space or an employment relationship. I will talk about preparation and resiliency for businesses with a little bit of additional information about I-9 audits. And then we'll go briefly over our standard know your rights advice for employees if ICE or immigration officers show up at a workplace. And then, as I said, I would like to leave as much time as possible at the end for questions. So let's talk about why this is important for Texas employers. As many of you probably already know, just through your day-to-day work, many sectors of the Texas economy are hugely dependent on foreign-born workers. This includes agriculture, construction, many aspects of the service sector. I read recently, the statistics vary a little bit depending on how you want to define certain sectors, but about 20% of the entire workforce in Texas is foreign born. That goes up to 40% of the construction sector, 50% of kitchen staff in restaurants and other sites, and about 50% of frontline agricultural workers, so people working in the fields, people working in meat processing. So hugely important industries for the state, hugely dependent on an immigrant workforce to keep their businesses going. Another thing to understand is that immigration statuses vary. It's not as simple as saying documented or undocumented most of the time. And not all immigrant employees are going to have the same status or the same legal rights. Um, and then lastly, speaking even more broadly, 1 in 3 children living in this state have at least one non-citizen parent. So you can see that the impacts of immigration enforcement are far-reaching. These are families that are fully integrated into our schools, our churches, and communities. So enforcement actions that target work sites have much broader impacts than just a single business. Looking more at the economic impact that immigration enforcement can have on our communities, just looking at undocumented immigrant contributions alone, household income for undocumented communities was about 13 billion in 2024. The undocumented immigrants paid approximately $800 million in federal taxes, and another almost 600 million in local taxes here in Texas. So the economic contributions of those without status are significant despite a lot of rhetoric to the contrary. You all probably know this, and I don't want to talk down to you, but why workforce stability matters? Well, if you have immigration enforcement actions that are arresting workers or keeping workers at home, that can create significant labor shortages. You can lose a lot of your institutional memory if you lose workers who have specialized knowledge and skills. It's hard to replace that. It costs money and time to train and recruit new employees or even find them. So being prepared for immigration enforcement now and not reacting to immigration enforcement after it happens is good for the rights and stability of the workers themselves and their families, but it's also good for businesses because it helps to mitigate the potential damage that an enforcement action might have on their day-to-day operations. So what does enforcement look like? This varies across the nation and even across the state, but I think there are a few specific modalities of immigration enforcement that are important to highlight in the context of businesses. The first and one of the more common are what we call collateral arrests or roving patrols. This is a situation where ICE may be out looking for a specific person that they have targeted for arrest, but in the context of that investigation or arrest, they just start to chat with people. They start to ask questions of bystanders or other people on the job site or at the house. Hey, where were you born? Do you have status or permission to be in this country? And because people just instinctively want to help law enforcement, they might answer more questions than they should and divulge information that makes them subject to detention and potentially deportation as well. This happens quite a bit in the context of a workplace raid, for example, where maybe they have a warrant for a single person, but they just start asking questions, and because people are scared, they get themselves into a situation where they're also detained. A big thing in Texas as well is traffic stops. I'm going to talk more about this in a little bit, but because local governments, specifically counties, and also the state troopers, DPS, have contractual agreements with ICE to carry out aspects of immigration enforcement. It's very common, particularly here in Central Texas, for a traffic stop conducted by DPS, for example, to end up leading to an immigration arrest. This is a big driver of the detentions we've seen in this region recently or over the past year and a half, I would say. Workplace raids are, of course, going to be front of mind for this discussion. We have seen in the news in the past, these can sometimes be very large-scale operations involving hundreds of officers and hundreds of arrests. There was one in Georgia, I believe, in 2025 at that scale, and under previous administrations, we saw similar raids happen in other parts of the state. The Panhandle was a big site for one of those, I think, back in 2018. but they don't have to be huge operations. We've also seen ICE show up at smaller businesses like a bakery in Brownsville or a smaller construction site and begin trying to conduct arrests or question individuals to take them into custody. Sometimes these raids can be targeting specific employees, and sometimes they might be targeted more toward the business themselves in where they are looking to inspect records or conduct an I-9 audit. I'm going to talk more about this later on. In the context of a workplace enforcement action, ICE might present different types of documents to justify their presence at the site. The type of document they present matters a lot because it dictates how much authority, if any, they have to actually enter a work site and look at records or talk to employees. That kind of leads me to the next thing, warrants. This is an important thing to emphasize over and over again. We do it in every Know Your Rights presentation. Only judicial warrants, warrants that have been signed by a federal judge or generally a federal judge, allow investigators to enter non-public areas of a business. ICE can produce an administrative warrant. That warrant only authorizes ICE to conduct an arrest against a particular individual. It gives them no authority to enter private spaces or search a home or search a vehicle or search belongings. It is simply to make an arrest, nothing more. As I said, judicial warrants are signed by judges, administrative warrants are not. I do want to emphasize that there is something called a Blackie's warrant. We have not seen this come up very much in this administration, but there are certain judicial warrants that do not simply authorize ICE to arrest a specific individual, but they give it broader authority to search a workplace to determine whether there are undocumented employees at that workplace. Again, this would be a warrant, though, that has been signed by a judge. An administrative warrant is not sufficient. Similarly, administrative subpoenas, which often come at the same time as an I-9 inspection notice, do not give ICE any immediate authority to inspect documents or to enter the private spaces of a work site. As I said, I-9 audits are a big modality for immigration enforcement in the employer context. As I said, inspection notices and administrative subpoenas don't grant immediate access to work sites. Typically, employers are going to have about 3 days to respond to inspections. This is an important time frame for employers to consult with counsel and make sure that they are prepared to comply with the audit notices in a way that mitigates the impact on their employees. All right. I mentioned before that the enforcement landscape in Texas is uniquely complex, and that is largely because of something called a 287G agreement. Texas already has about 300, I should back up. A 287G agreement is a type of contractual relationship between ICE and a local law enforcement agency where that local law enforcement agency takes on some of the responsibilities of immigration enforcement. This can range from relatively low impact agreements where maybe a deputy in a sheriff's office is designated to serve immigration warrants on people housed at the county jail, but it can ratchet up to what's called a task force model where specific officers are trained to carry out immigration enforcement directly without ICE being present for those arrests. Under a law that passed last May called SB 8, pretty much every county in the state is going to be required by the end of this year to have some type of 287G agreement signed with ICE. The scope of those agreements will vary by county. You can check our website at txilc.org for the most up-to-date information about which counties have entered into which agreements. But we can see already we have about 370 active 287G agreements covering 289 law enforcement agencies throughout the state. This is a fifth of all of the agreements nationwide. This means that there is intense collaboration between local law enforcement and immigration enforcement in this state. Beyond that, it's important to emphasize that DPS has also entered into a statewide 287G task force agreement. Task force agreements are the most intensive of the types of 287G agreements that exist. And that's why we've seen a lot of instances, especially here in Austin and in the region, where a DPS traffic stop very quickly turns into an immigration arrest. Um, all right. So, oh man, I wish it didn't actually play the key. Sorry about that. So some important considerations at the start of this discussion. The constitutional rights that we often talk about in the context of individual arrests apply equally in the context of commercial spaces. So, business owners, clinic operators, school administrators also have the right to deny law enforcement entities access to non-public spaces when they don't have a valid warrant. Similarly, employers and certainly employees have the right to not answer questions or self-incriminate and to request a lawyer if they don't have one. So that means, and I can't emphasize this enough, state and federal law enforcement, that includes ICE, that includes DPS, it includes APD, they cannot enter commercial premises that are not open to the public without consent from the business owner or without a warrant. They cannot seize paperwork or inspect paperwork on a business site without consent or a warrant. And it's very important to understand, even though this sounds a little strange to say, entry in a property, even if it's by a law enforcement agent, if after that notice of that entry is forbidden, if they don't have a warrant and they try to enter anyways, or if they fail to depart after notice is given that they are not allowed to be on site and they haven't produced a valid warrant, that is criminal trespass, and it would make the trespasser subject to arrest. So I say this all the time. If ICE shows up at your job site, they can't produce a valid search warrant or arrest warrant signed by a judge that gives them permission to be there, and you ask them to leave and they don't, you are within your rights to call local police to come and sort that out. I'm not saying that APD or the Travis County Sheriff is suddenly going to start arresting ICE agents, but they can figure out the legality of the situation. You should not have to, and it might deter immigration enforcement officers from conducting any more questioning or arrests on the site and protect your workers. Given what I just shared, it's very important for all business owners to be quite clear with themselves and also with the public about what the public and private areas of their business are. Because the reason for this is law enforcement agents do typically have the right to enter areas that are commonly open to the public, just like any other customer. That would include places like a dining room in a restaurant, the lobby of a building, the retail floor of a business, waiting rooms, reception areas, parking lots. All of those places are open to the public, and there's no requirement that law enforcement produce a warrant to enter onto those places. Private areas are the areas where you can refuse entry to officers or anybody else. So, the same way I can't walk into the kitchen of a restaurant, a police officer or an ICE agent can't either unless they have a permission or legal authority to do so. Same is true for stock rooms or storage areas, employee break rooms, manager or office spaces, employee-only hallways, and behind service counters. I've said this in other presentations, but the general rule is if Bobby Painter can't walk into a space, then a cop or an ICE agent can't either unless they have permission or legal authority to do so. It's very important for employers, keeping this in mind, to clearly delineate which areas are public and which areas are private. You can do this through signs, through closed and locked doors, through implementing badge or key access to private spaces, and being consistent about where the public can and can't go. The clearer you are, the clearer it is for your staff and for law enforcement or anyone else where the constitutional rights that protect you start. So I mentioned the Fifth Amendment before. Again, this is your right not to incriminate yourself, not to sign documents, and your right to due process before the law. And this applies in the business context in the case of I-9 audits or anything else. You do not have to answer questions or produce files or property simply because you have been given a notice of inspection. You have typically, as I said, 72 hours to respond to that. And you should know as an employer that you and your employees don't have to answer questions about employee roles or the status of individuals or where those documents are being held or any of that pursuant to your Fifth Amendment rights. All right, I mentioned before warrants, valid and invalid, it's always helpful to do the side-by-side comparison. On the left side of the screen, you will notice this is a judicial warrant. It will have a heading that makes it very clear that it's coming from a court, usually a U.S. district court, and it will outline the nature and the scope of the warrant, the authority that that officer has to come on site and conduct an arrest or a search. Most importantly, it will have a judge's signature at the bottom. On the right, you will see what is called an administrative warrant. This is a warrant issued by the Department of Homeland Security, essentially giving frontline officers the right to arrest a specific alien or non-citizen, excuse me. It will not have a judge's signature on it. It will typically just be signed by a senior ICE officer. The same is true for what are called administrative subpoenas that come in the context of an I-9 audit. They don't carry any immediate judicial authority. Non-compliance with an administrative subpoena can lead ICE to go to a judge to get a real search warrant. But they are typically, they're different. They're not issued by a judge, and they don't produce any immediate obligation on the part of the employer to respond. All right, so talking a little bit more about I-9 inspections, again, a notice of inspection or subpoena does not give ICE any authority to enter private spaces or demand to review records or to speak to employees. You have 72 hours to provide documents. You also don't have to keep copies of all the documents provided for an I-9 completion, just the form itself. So for instance, if you have an employee who has produced a unrestricted social security card and a state ID to support their I-9, you can keep copies of those documents, but you only really need to keep the form itself. And it's usually safer to only keep the form rather than your employee's identifying information, especially if that is a work permit. You also don't need to keep your I-9 documents on site. The law just requires that you keep them in a centralized location, but that does not mean that it has to be a file drawer in your back office of your restaurant or other business. Really important to get counsel if you think that you might be subject to an I-9 audit. As we said at the beginning, this is not individualized legal advice. This is just information to help you better prepare. And we don't know the specific circumstances of your business, your record keeping, or any potential I-9 inspection notice that you get. So very important that you contact a lawyer immediately. It's good to have a list of people in mind or somebody on retainer so that if you are subject to an inspection, you can move quickly to respond appropriately and lawfully. Very important, as always, do not waive your rights, your Fifth Amendment rights or your Fourth Amendment rights, by voluntarily consenting to a search. An I-9 inspection notice is not a search warrant. You do not have to consent to a search if you are presented with one. Also very important in this context to be clear with yourself and your staff about who's going to respond in the event that somebody shows up with an inspection notice or an administrative warrant or anything else. You should designate one person. That person should have lawful immigration status and ideally be a U.S. citizen to respond to any law enforcement agency that shows up at your business. This person should know how to contact counsel or at least a supervisor who knows how to contact counsel. Employees should be clear on who to get if ICE shows up at the business. And that designated person should be prepared to document everything. So the agency involved, the names of the officers, the types of documents they have presented, all of that they should make note of, date, time, etc. And they should be clear on what the next step is, whether that's to contact their boss or to go right to a lawyer to figure out how to respond. All right, let's turn for a second to talk about employees and their rights in the context of worksite enforcement. Very important. Employees should not and do not need to answer any questions or consent to a search of their person or their belongings unless an officer presents a valid warrant to search their belongings. And a warrant doesn't require them to answer questions either. They have the right to ask the name and the affiliation of the officer. They have the right to confirm whether or not they are being detained. And if they are not being detained, they have the right to ask if they're free to leave. And if they are being detained, they can clarify why. They have the right to remain silent. If they choose to exercise that right, they should say so loudly and clearly. They can also present one of those Know Your Rights red cards that explains that they will remain silent and that they wish to speak to a lawyer. If they are under arrest, they can speak with a lawyer and should before they sign anything or answer any questions beyond their name, date of birth, and home address. Texas law does require people who are subject to arrest to provide that information, but under no circumstances is anyone required to answer information or answer questions about how they came to the US, where they were born, their immigration status, anything like that. You never have to answer those questions, whether you're under arrest or you're just being asked casually by a local police officer or ICE. If you are a bystander to a worksite enforcement action, under Texas law, you are allowed to record as long as you are not actively interfering with the arrest, and I highly recommend doing this. Employees should not panic and run. If they're afraid and they feel like they need to walk away, they should calmly walk to the exit. If they are stopped, they can ask if they're free to leave, and if they are told yes, they should do so. If they are told no, that is when it's time to invoke the Fifth Amendment and stop answering any additional questions. They should not lie. They should not show false documents. They should not show identity documents that say what country they are from. So consular IDs or foreign passports, better to not present those. They don't have to. They should also not line up or stand in groups according to their immigration status, even if they are requested to do so by the officers. And of course, they shouldn't be shouldn't be interfering with law enforcement activities. So attempting to hide other employees or help them run or blocking an entry point, all of these things could create potential criminal liability for the employee. So better to just remain silent and leave or stay put than to try to interfere. All right, so here's kind of a complicated to read flowchart that walks through a lot of what I just said. So the first thing I want to say is it's really important to stay calm in the event of a law enforcement action at your job site because you're going to set the tone for the interactions that follow. As I said, make sure that everyone on your team knows who the point of contact is if ICE or any local law enforcement officer arrives. I keep saying local because I haven't mentioned this in this presentation, and I don't have time to cover it, but Texas Business Code also gives the Attorney General's office pretty sweeping authority to inspect business records and conduct job site inspections. And in those contexts, just like in the context of an I-9 audit, it's important to have the same designated person be ready to review any documents they present and confirm what agency they're with before responding to requests to examine records or to speak with employees. The same basic principles attach, even though the law is state law rather than federal law. All right, so what do you do? What does a designated person do if somebody shows up asking to look at records, to talk to employees? First and foremost, ask for identification and ask them to produce the documents that they believe authorize them to do that search. Do not consent to a search until you've looked at those. Even after you've looked at them, you aren't responsible for determining the legality of those documents. Next step is to contact your supervisor, the owner, or an attorney immediately. Don't answer questions while you're doing this. You don't have to answer questions while you're trying to get confirmation from somebody else about the documents. Once the attorney reviews those documents and advises on next steps, you can figure out what the course of action should be. If they produced a valid search warrant and the attorney has confirmed that, then you have to consent to the search, but the attorney will tell you what the scope of that search should be, what can and cannot be searched, and give you a plan for how to proceed. If it is not a judicial warrant, it's one of those administrative warrants that I mentioned, you do not have to consent to entry into private areas. You can politely state you're not consenting to the search, ask the officers to leave immediately. As I said before, document everything. Who came, what agency they were from, what documents they gave you, where they went, did they take anything, what time did this happen, who did they talk to? Again, as always, don't physically interfere with the officers or attempt to block their actions. You can record Do not obstruct or resist. We say this because it could potentially create criminal liability for the employee or the employers, but also escalate a situation where somebody could end up getting hurt. And we want to emphasize that physical safety is paramount in all contexts. And again, I want to emphasize over and over, it is not your job or your designee's job to decide whether ICE is acting lawfully. They may be, they might not be. They often don't. Your job is to recognize the documents they present, make sure that they present those documents, and contact counsel, and to respond. All right. Well, that was actually we made it through. So we have lots of time now for questions. I'm going to stop sharing, and we'll get going.
Great. Thank you so much, Bobby. We do have several questions, and the first one I do want to address. Some folks have asked about the recording being posted. I am going to go ahead and end the recording at this time because we are moving into the Q&A portion.